2 weeks ago, NITA staff member Kathy Behler received a notice to be summoned for jury in federal district court. We're here today to talk about her experiences as serving on a jury. So Kathy, busy day at work, you come home, get your mail, and there in your mail you find a summons from the federal district court calling you to jury duty. When you got that, how are you feeling?
Well, I don't think anybody really says they get excited when they get that. It certainly wasn't good timing, and I wasn't really looking forward to it.
Were you hoping you would be excused if you could?
Yes.
You show up that day for court, get called into the courtroom, put in the jury box. Who's conducting the questioning of the prospective jurors?
The judge.
Only the judge?
No, he asked the majority of the questions. He pretty much interviewed all of the potential jurors one by one, asked them about their lives, and if and when they had any experiences pertaining to the case, he would delve a little bit deeper there.
All right. The lawyers had a chance to interview you as well, right?
Yes, they did. The judge gave them about 5 to 10 minutes each to ask individual jurors questions, again, mostly to containing the subject matter of the case.
Did you feel any of the questions were too personal?
No.
Do you think they got the kind of information they needed from all of the jurors before they told people they wanted them to stay?
Yes.
Okay.
Yes, definitely.
After you're impaneled, the judge is starting the case. How'd your mind change?
I would think at that point, you're there and you have to be there. So you get a little bit more of an open mind about it. You look at the party members of the case and you think to yourself, well, if it were me, I would want somebody to give me their time. And so I felt that I would do the same for them.
Why do you think your feelings changed after you were impaneled?
Because of that, because you look at the members of each side and you think to yourself, if it were me, I would want somebody to pay attention, to listen and try to decide as best they can. So even though I was there, I had things going on in my life that certainly by being there wasn't helping. I made it a point to myself to pay attention and really try to get the facts of the case and make an informed decision.
Did you get a sense that the other members of the panel felt the same way?
For sure, absolutely. I think all of us had stuff going on in our lives. We were able to talk about that, but they felt the same way for the most part.
Did you talk about that as you were deliberating or anything like that?
Yes, we did. Knowing that we all had stuff going on in our lives, we wanted to make sure that we didn't let that hinder our decision. So even though we were fairly confident at several points during the deliberation process as to what we were going to do, we made sure that we were following the instructions and considering each point.
What type of a trial was this, civil or criminal?
It was a civil case.
Trial begins, both lawyers offer opening statements. And after you heard those opening statements, did you have an idea about how you would vote at the end of the case?
Me personally, no. I didn't really feel either attorney did a very good job with the opening statements. I think that I was still very confused as to what the case was about, exactly what decisions we were going to be making. So So I was, like I said, I think I kind of left that still a little confused. I may have been a little prejudiced considering my workplace. I knew a little bit more what was expected from an opening statement, and I just didn't feel like either one of them just nailed it.
Would you have preferred to hear more of a story in terms of what the opening statement was about?
Yes, I think that the plaintiff's attorney did a pretty good job with that. What I needed was a little bit more of what you can expect. You know what I mean? I needed a little bit more organization to it. You know, this is what we're saying, and this is how we're gonna prove it, kind of thing.
Okay, introduction of witnesses, for example.
Right.
Talking about exhibits you might see.
Right.
All right, so
More, just a better idea, better understanding of what the case was going to be about. Again, I left both afterwards still wondering, what are they asking me to do here, you know?
okay, so let me follow up on that last point. Did you have any sense of what they wanted you to do at the conclusion of the case?
I had some sense, but not a solid sense.
And what do you mean by some sense?
I knew like the generalities, what the case was about, but not really like what they were asking me to do quite yet.
Did they suggest an amount of money if you would fine for them?
No,
or anything
actually,
like that?
the funny thing about that was the financial part of it just never really even came into question, what they were looking for.
Okay. Witnesses are called to the stand. As the lawyers were doing their direct examination or asking the witnesses to tell their story, did in fact they allow the witnesses to tell their story?
Definitely. You know, both sides or each side kind of had a main witness to the case, and we definitely left both of those feeling we knew each person and their personalities, for sure.
At any time, did the lawyers sort of put words in the witness's mouth?
On direct?
Yes.
No.
Okay.
No.
Very good. Shift to cross-examination. Did cross-examination have you change your mind about any of the witnesses?
Definitely for the plaintiff's witness when she was cross-examined, for sure. And she did a great job at it. The lawyer, really counterpointed everything that the direct examination discussed. So that helped make the case a little bit more clear to us. You know, she would say things like, you know, so you said this, but here's A, B, and C, Y as to how that's not true. Like, how can you say that? Kind of things. Her cross-examination was just that, these little yes or no questions that led to an ultimate point that she was trying to make, that the witness really couldn't say anything but, you're right, you know what I mean, or whatever. And she wasn't personable with the witness, but at the same time she wasn't condescending or rude or anything like that, just simple yes or no answers. I mean, she literally was checkpointing after every single question, which just helped make her point to the rest of us.
Cross-examination is going on, and she's making those little points, one after the other. Do you think you reached a conclusion before she even finished the exam?
Absolutely. I mean, you knew by the time she got to that last question, or you knew what point she was trying to make, you know, halfway through making the point. And then because she had still this other, you know, few more questions, it just solidified it in your mind.
Now, did she talk about that cross-examination in her closing argument?
She didn't, because she wasn't the main counsel.
Okay. Did the other lawyer talk about?
Not that I can recall, no.
Nothing about why you shouldn't believe this witness or anything like that?
Not really. We can go to his closing statement, I guess, when we get there, but he had some good things. But I don't think it was directly related to her cross, no.
During the examination, either direct or cross, did the lawyers make use of any exhibits?
Yes.
In terms of making use of the exhibits, did they actually have the witness talk about it?
Yes, I mean, in several times, the really nice thing is, almost everybody gets their own little TV to look at. So the witness had that. So the witness not only had what the lawyer was bringing up on the television, but then they had hard copies too that they could go back and look at to help refresh.
When you were deliberating, did you go back to those exhibits to look at them when you were making your decision?
A few of them, but for our particular case, several of the exhibits were brought up 3 and 4 times. So we really kind of knew which ones we were talking about when we were talking about it in the deliberation process.
How many exhibits do you think really were important in the case?
Oh, maybe a handful, 6 or 7.
How many exhibits did they actually introduce?
I think they were up to like 60. The plaintiff's attorney had to introduce a couple during the process, and I think it was around 60 or so.
Yeah. Let's shift and think about the use of visual aids as opposed to exhibits. During the whole trial, did the lawyers make any use of PowerPoint or blow-ups or models or anything like that?
Yes, and I don't want to say that it was a key factor or deciding factor, but the defense attorneys group had some very nice software where most of the exhibits were emails or documents, that sort of thing, so they would highlight it and blow it up. So you were just looking at like the paragraph they wanted you to focus on, or 2, they would highlight, the particular line that they were talking about at that time. 1, it helped the process of the trial go faster. The witness isn't sitting there kind of trying to look at what they're talking about. The jury members weren't doing that. And secondly, it really kind of hid anything else in the document that maybe they didn't want you to see, and I think that was particularly effective for them.
When you went back as you deliberated and looked at those documents, did you do anything more than just look for those pieces that the lawyers talked about?
Myself in particular, no. But I think some other jury members, yeah, they did go back through and kind of make sure they read everything in it. But again, it was only really a handful of exhibits that we were really focusing on, and they had been brought up so many times that different areas were talked about at different times during the case.
Let's shift to closing argument. You've already mentioned closing argument a couple times. In closing argument, did the lawyers specifically tell you what they wanted you to do?
Yes, again, the defense attorney, his closing argument was effective once it got to the point where he literally took the questions that we were supposed to answer. He had them on a PowerPoint presentation. He had yes or no underneath it. And as he read each question to us, he checked whether or not, to vote yes or vote no, whichever one pertained to his side. And then as he talked, A, B, and C reasons why would pop up. And it just really helped solidify everything in my mind as to why to vote that way.
Did that, when they finished closing argument, had you already made up your mind how you were going to vote at that point?
By the time the case was over, it was pretty clear. For me, you're not allowed to talk to the other jurors about it and stuff, so I did wonder if everybody else in the jury was feeling the same way I was feeling. But for me, yeah, by then it was pretty much decided, and I would say that his closing argument, all he did was, by doing that, was just reinforce the fact that we should be, voting that way.
The judge gave you some instructions before you went back and deliberated.
Mm-hmm.
When you started that deliberation process, did you go back and refer to those instructions?
We did on several matters because we just didn't understand the questions. Some of the way the questions were read were hard to understand, so we would have to refer to his instructions to make clarity on that.
Did the lawyers in their closing make any reference to the jury instructions as well?
Not that I recall, no.
All right. What did you take away from that deliberation process?
The whole experience in itself was actually, a very unique, good experience. I was, almost happy to have done it. In the jury selection or the deliberation process itself, I think for me, I couldn't leave the situation thinking, I didn't want the fact that I had made up my mind before we even got in there to really kind of hinder why or to try and make it go faster than it was. So my biggest thing was, that we're giving this a fair shot, that I was listening to other people's opinions, and that I just couldn't leave the experience thinking that I made a poor decision for any reason other than not following the instructions or, giving the case the time it deserved.
Sure. Were there any things that the lawyers did during the trial that kind of bothered you or distracted you from hearing the evidence?
Yeah.
What were those?
The plaintiff's attorney would visibly get upset if the witness said something that he didn't agree with. He was very aggressive in the way that he talked to the defense's witnesses. And it was bothersome. It didn't, I don't know if he was just a very emotional person, and he was just very, very close to the case, and he was doing that just because that's kind of how he is, or if he was intentionally doing that to try and get a response out of us. If it was intentional, it did not work.
Did you feel that he was not showing the kind of respect that those witnesses deserved?
Absolutely, and I just think that there are more effective ways to get somebody to admit they did something wrong besides bullying them or being aggressive towards them. Because by no means was the defense or either side did everything perfectly, because they certainly didn't. But I just don't think that that's the way you get it out of somebody. And after speaking with some of the jury members about my feelings about that, everybody kind of felt that way with him.
Anything else the lawyers did during trial that you found bothersome?
I myself know some of the other jurors mentioned the defense attorney kind of thought he was a little condescending, a little pompous. I didn't think that. It was clear that he had some experience, but some of the other jury members felt that way.
Again, do you think it was something that suggested a lack of respect?
Yeah, I mean, he on occasion put down the plaintiff, and I think that that rubbed some of the jurors wrong. Let's
look at the other side. Tell me some of the things that the lawyers did that you really liked.
The plaintiff's side, again, he was clearly very emotional and very close to the case. You kind of felt like he you know, he was there for her, you know, or for the plaintiff, and he was going to, you know, do whatever he could to help her. He clearly, you know, just felt very strong about the case. Whereas, you know, the defense's side, it was just more a matter of, you know, business. We're just, you know, I'm here because this is my job. This is what I do. You know what I mean? Not the relationship
Sure.
between the attorney and who they were representing just didn't seem as strong.
You mentioned earlier about how the one side used PowerPoint in their closing.
Mm-hmm.
How much did that affect you?
I think it was extremely effective. It just kind of solidified or made clear, you know, what I already had in my mind, or what decisions I had already had in my mind. And like I said, it was just, you know, vote this way. Why? Because of A, B, and C, and it was out there for you. I found myself, basically my note taking was during that, and pretty much just ripping what he had on the PowerPoint presentation so that I could go back and yep, he's right. You know, this shows that.
If he had not used the PowerPoint but made the same points just in speaking to you, how do you think that would have affected things?
I think he would have lost everybody. As I felt that they both did in the opening statements, there was, you know, he would have lost it. It helped stay on track.
Last question for you.
Okay.
Next time you get a jury summons, how are you going to feel?
Well, I have a 2.5-year pass now, but I'd probably be a little bit more open to it. You know, I wouldn't be so closed off. I wouldn't, you know, maybe I wouldn't go into it trying to, like during the voir dire, or during when the judge was asking us questions, you could see people were trying to find reasons that they could show they were biased, you know. And maybe they won't do that next time. I certainly wouldn't, you know. Yeah, I don't think I would be as turned off by the situation.
Kathy, thank you so much for sharing your thoughts about this.
You're welcome.
It was really very helpful.
Happy to be here. Thank you.
Great.